Military judge. Trial counsel. Do you have a short rebuttal? Trial counsel. Yes, Your Honor, it is brief. Prosecution rebuttal on findings by Circuit Trial Counsel. Members, I have 3 points. They are brief. I'll give you my word. I want to talk to you about something called the shiny monkey technique, and it's something that trial lawyers sometimes use to draw your attention on what they want you to pay attention to and away from what you should be paying attention to. Pay attention to these things and not these. What I would ask you to consider, basically in this case, is that every time the government investigated one of Brie Larson's allegations against her husband, it turned out to be true. It's a bit of an uncomfortable fact for the defense, isn't it? It's making this the Brie Larson show. When Brie Larson says this happened, and this happened, and this happened, every single time it was investigated, it just happened to be true. Let's start with the party crew. The government can speculate too. Perhaps they're overseas. Perhaps they're all in jail. Perhaps they refuse to talk. Perhaps they this, perhaps they that. Perhaps there was no more than enough evidence to convict Captain Larson of all the charges he's been charged with. Defense counsel, objection, speculation. Military judge, both trial and defense have done it, but let me just remind you, you're not to speculate about information that's not there. Move on, please. Yes, Your Honor. The second issue I want to talk through with is if all this comes down to Brie Larson, if her goal was to get back at Captain Larson, her goal was to frame him, why in the world did she agree to an annulment where all she got was a vase and $2,000 in debt? Didn't touch his car, his precious car, didn't touch his money, didn't touch the house, didn't touch anything. She got a subpoena and an order to testify. Third point for you is that in order to believe that all of this is a grand conspiracy against the accused, there's no explanation for why she left the house wearing nothing but a blanket. How has she planted Captain Larson's fingerprint and only his fingerprint on those drugs? How she coordinated with a drug dealer, and how she put Captain Larson's phone number and called him Captain America in Mr. Drug Dealer's phone? How she coordinated with the party crew? How she doctored his leave records? How she convinced him to talk about drugs? How she planted messages in his phone with a friend? All apparently while taking responsibility for herself. The government's only going to ask you to do 2 things: apply the law and consider the facts. Law and facts, members, that's it. Based on the law and based on the facts you have in front of you, there's more than enough evidence to demonstrate Captain Larson's guilt. When you take the law and when you take the facts, there's only one verdict that you're going to be able to return. Not the shiny monkey, but the facts. And those facts demonstrate guilt. Military judge. Members, if you believe you heard either counsel express their personal opinion about witness's character or the strength of the evidence, you may not consider it for that purpose. Counsel are not permitted to offer their personal opinions. This was merely argument. Neither counsel's personal conduct in court are matters relevant for your consideration in resolving the matters before you. You alone determine the credibility of the witnesses and whether the government has proven the elements of an offense beyond a reasonable doubt. The military judge completes the orders. Military judge, please be seated. The court is called to order. The parties are present, the members are absent. Captain Larson, you can remain seated, but when the members return from their deliberations, if you are acquitted of all charges and specifications, that will determine the trial. On the other hand, if you are convicted of any offense, then the court will determine your sentence. During that part of the trial, you will have the opportunity to present evidence in extenuation and mitigation of the offenses of yourself, which you want the court to consider in deciding your sentence. In addition to the testimony of witnesses and the offering of documentary evidence, you may testify under oath as to these matters, or you may remain silent, in which case the court will not draw any adverse inference from your silence. On the other hand, you may make an unsworn statement. Because the statement is unsworn, you cannot be cross-examined. However, the government may offer evidence to rebut any statement of fact contained in an unsworn statement. The unsworn statement may be made orally, in writing, or both. It may be made by you or by your counsel on your behalf, or by both. Do you understand these rights that you have? Kevin. Yes, sir. Military judge. Defense counsel. Has the accused been punished in any way prior to trial that you believe would constitute illegal pretrial punishment under Article 13? Defense. No, Your Honor. Military judge. And Captain Larson, is that correct? Has anyone done anything, commanders, to punish you prior to this trial? Kevin. I have not been allowed to wear my flight suit. Military judge. Okay. Have you had an opportunity to talk with your defense counsel to determine whether or not the circumstances of that would such be illegal pretrial punishment under Article 13? Defense. May I have a moment, Your Honor? Military judge. You may. Kevin. No, sir. Military judge. So have you had an opportunity to discuss the circumstances with your defense counsel and whether or not you believe that would constitute illegal pretrial punishment? Kevin. Yes, sir. I do not believe it is. Military judge. Okay. Thank you very much. All right. Based on the information on the charge sheet, trial counsel, do you believe that the accused is not to be credited with any pretrial confinement credit? Is that correct? Trial counsel. That's correct, Your Honor. Military judge. Defense counsel? Defense counsel. We concur with the court's readings of the charge sheet, Your Honor. Military judge. Okay. And let me ask you the question, because at least there was a reference at one point to him being arrested. Was he confined as a result of that such that he should get any additional credit, do you believe? Defense counsel. Yes, Your Honor. So our understanding is when he was arrested, he was in jail for 1 day. Military judge. Okay, all right. Trial counsel. Do you have a position on whether or not he should get 1 day of pretrial credit? Trial counsel. Your Honor, at least the government's position is that under the dual sovereignty principle, civilian law enforcement wasn't acting as an agent of the United States. And so I guess our position, I apologize for not being well briefed on this, Your Honor. Military judge. All right, that's fine. So what we'll do is I'll give trial and defense counsel an opportunity to review that. And one of the things I'd like for trial and defense counsel to be able to respond to is whether or not he was confined, if he was confined, based on all offense, based on what offenses. So for example, was it mushrooms? Was it an assault consummated by battery that's been charged here? Or was it something totally different? So I'll give you an opportunity to look at the issue as well as the applicability of that to whether or not he should get pretrial confinement credit. And obviously that would be potentially tied even then to whether he is obviously found guilty beyond a reasonable doubt, what offense, if any. Counsel, do you have any documentary evidence on sentencing if that letter becomes necessary, which would be marked and offered at this time? Trial counsel? Trial counsel. Yes, Your Honor. Military judge. All right, you may proceed. Trial counsel. The government has prosecution exhibits 17 through 21 for identification. May I go through these and list them? Military judge. You may. Trial counsel. Okay, so prosecution exhibit 17 for identification is the accused personal data sheet. It is a 1-page document dated 13 January 2020. Prosecution exhibit 18 for identification are the accused officer performance reports. It is a 12-page document dated 6 January 2013 through 1 December 2018. Exhibit 20 for identification is a letter of counseling of the accused. It is a 7-page document dated 20 August 2018. Prosecution Exhibit 21, identification is a later of the admonishment of the accused, and it is a 10-page document dated 27 September 2018. The court-martial president read the findings. Captain Kevin A. Larson, this court finds you. He continued to read the list of findings of 17 charges and specifications. Military judge, you may be seated. Kevin and the defense counsel complied. Military judge, bailiff, if you would please retrieve the findings worksheet from the president and provide that to the court reporter. Trial and defense counsel, before we proceed, would you like a short recess, or is this a good time for lunch recess before we proceed so that you can review the findings? Defense counsel, yes, Your Honor, we would like a brief lunch recess. Military judge, what I'll do is I'll give you, because again, you haven't had an opportunity to take a look at the findings worksheet, I'll put you in a recess until 5 after 2, and that way, if there's any issues or questions you need to bring to the court's attention based on the findings of the court, we can certainly address them at this time. The court is in recess until 5 after. I got the call I was waiting for. I've got the verdict for you. Ready? She said with a sigh of relief. Yes, I'm ready. Domestic violence, guilty. All the drug charges, guilty. Perjury, guilty. Lying to the commander, guilty. Smashing your phone, not guilty. Distribution to an airman, not guilty. Admitting to kill himself, not guilty. She explained that there were several charges and specifications, around 17 of them, and for most of them he was found guilty. Wow. I mean, they heard my side and validated me. It feels so good. Wow. I didn't expect this to be my response. Like, oh God, it feels so good. Like, liberating, you know? I was long-winded and didn't know how to stop. Wow, okay, so, what's next? Sentencing? I mean, I don't need anything more. This is all I could have ever wanted, like, for the truth to be accepted. God, I wouldn't even care if he did any time. Like, this would be the perfect scenario. I continued to trail on. I'm surprised with your reaction, too. I wasn't sure how you'd respond, actually. Well, I'm glad. So, you have a couple more rights as a victim following the sentencing. First, there's basically another level within this judicial system that can lower his sentence and work with him based on the letters of character, which he has about 60, etc. So you definitely have a right to be involved in this and give your input as to why or why not the sentencing is fit for his crimes in your eyes. Also, you have a right to be informed of his whereabouts and when he's released from prison. What are you comfortable with? No, thank you. I want to leave this all behind me. I feel like this is enough for me and I just want to drop it. He's got enough to deal with as it is. Yeah, that's true. You're always entitled to know your options. Finally, I felt like I could breathe for the first time in years. This was going just as I could have desired. I let it go to God and we're here. I called my mom right away to tell her the good news. About an hour later, my lawyer called again. So, Bree, we kind of have a situation. He's gone and we don't know where he is. What do you mean he's gone? Like he just disappeared? Yeah. After the conviction, we took a break for sentencing and now we have no idea where he's at. You're the first person we thought of who might know where he's going. Honestly, I meant it when I said he would kill himself. No one would believe me, but that's what he'll do. I can't think of anywhere he'd go or anyone he trusts. All right, well, we also want to take your safety into consideration. Does he know where you live? Yes, he does, but he wouldn't do anything to me. I know he wouldn't. Okay, you can't be too careful. We'll send OSI over there to ensure you're safe. I'm okay, I promise. All right, well, it looks like we're going to go ahead with sentencing without him. I'll keep you in the loop. Also, I know you wanted to waive being contacted about his whereabouts, but I'm assuming now that has changed. Yes, oh God, please keep me updated. Will do. About an hour later, I got a text from her again. We pinged his phone and now it looks like he may be in California. Do you know anyone in California who he'd be in contact with? I responded with, I have no idea, but I bet he's headed to Mexico. I don't think he'll make it past the border, she responded. I happened to be picking up Sean from the airport within the hour. Not that I felt like I would be in danger, but I liked knowing that either way, I'd be in good hands. Our romance had evolved since we met in December, bonding over what drives us, love and truth. That night, for the first time in years, I allowed myself to just let loose. The real reason he was in town was for his pre-grand owners-only opening party for a restaurant he owned. Being his +1, I got to sample their drink menu. We ate and drank like kings and queens. A strange, unfamiliar feeling came over me that I, for the first time in 23 months, was able to just let go. Session was called to order at 08:21, 18 January 2020. The parties, with the exception of the accused, were present. The members were absent. Military judge. Please be seated. The court is called to order. The parties, with the exception of the accused, are present. The members are absent. It appears as though the accused is still absent. Trial counsel, what is the way forward? Do you intend to put any evidence or information regarding whether the accused absence is voluntary? Trial counsel, yes, Your Honor, we do. We intend to call one witness and request permission of this court to proceed in absentia. Military judge, just as an initial matter, defense counsel, do you have any information at this point, any position, defense counsel, to offer before I take the next witness? Defense counsel, Your Honor, no additional information or evidence, nothing of that sort. However, we do disagree with the contention that Captain Larson is, in fact, voluntarily absent. Military judge, I understand. Thank you very much. You may call your first witness, trial counsel. Trial counsel. The government calls Special Agent Johnson. The U.S. Air Force was called as a witness for the prosecution, being duly sworn, testified as follows. By Circuit Trial Counsel. Agent Johnson, I understand that you're a special agent with the local OSI detachment here at Nellis Air Force Base. I am. And that you're the primary point of contact to the government's attempt to locate Captain Larson, the accused in this case. I am. All right, I have a few questions about some of that information you've learned, at least with respect to OSI's attempt to locate Captain Larson. Do you have any indication at this point where Captain Larson is? Specifically, no, but a general area as of 10 o'clock last night, yes. Where? Southern California in the LA general greater area. Okay. In conjunction with Captain Larson's absence from this court-martial, was OSI contacted to do an investigation as to his whereabouts? Yes. Do you have any information as to whether Captain Larson or a vehicle attached to him left Nellis Air Force Base at approximately noon yesterday? We have CCTV footage of his vehicle, the blue Chevy, leaving the base at around 1:30 yesterday afternoon. What can you tell the judge as to any other CCTV footage that you have analyzed or reviewed in conjunction with your investigation on this matter? The agents have received or are reviewing CCTV footage that discloses that at about 10 or so the night before, he was seen parking his vehicle at a restaurant at the northwest area of Las Vegas. So I want to be a little more specific. So you said 10 or so the night before. Is this last night? No, this is the night prior to his conviction. Okay, and you said his vehicle. What vehicle? This would be his Jeep Wrangler 2018 dark blue. Several moments later, this Subaru Crosstrek pulled up with a different occupant. They conversed for about 30 to 40 minutes, and then they departed in the Subaru, leaving the Jeep in place at this restaurant. Okay, and what were you able to determine as to what relevance this Jeep has to do with this inquiry? Following his departure from base, or his vehicle's departure from base at about 1:30 after his conviction yesterday, that vehicle was seen pulling up to his Jeep at the restaurant. He was identified by both CCTV footage in his blues, as well as the restaurant employee who was shown a photograph of him and said that was him. All right, and him being Captain Larson. Correct. He exited his Chevy, threw a bag into his Jeep, and departed. All right, now after this moment, do you have any idea as to where Captain Larson went, and if so, how do you know? We conducted an exigent circumstance ping through his cell phone carrier, which showed that he was on the I-15 southbound at the Nevada-California border. A subsequent ping showed him traveling southbound on the 15 towards the Los Angeles area until about 10 o'clock last night when he was in La Brea, California. And to the best of your knowledge, has Captain Larson contacted by message or otherwise any person since his disappearance? Yes, multiple messages have gone out to numerous individuals. Can you describe in general terms what those messages discussed? Some discussed suicidal ideations, others discussed fleeing and coming back when he was ready, and some also discussed fleeing to Mexico. All right, and based on the direction of his travel, is that travel in the direction of Mexico? Yes, there's a major border crossing in the San Diego area. Is there anything about the content of those messages that suggests that it was, in fact, Captain Larson that sent those messages? There was a message talking about the fact that he was recently convicted, he was found guilty, and then expressed whether suicidal ideations or the desire to flee. What about reference to the person who was believed by the court-martial? What are those messages saying about that? It was said it was unfortunate, I believe it was the victim, his ex-wife, was believed above him. All right, I'm going to ask you a more specific question. The language of those text messages, did it say something about his wife, my wife? What was the language of the messages that suggested that it was actually Captain Larson that sent that message? I'll have to review the messages again. All right, that's all the questions I have. Defense counsel, to your knowledge, was Captain Larson alone when he left? I do not know. Okay, so you're unaware if there was someone with him who may have had similar knowledge to the things that were discussed in those text messages. We are aware that I believe his girlfriend was with him at a time. However, she was contacted by Metro and he was not with her. Okay, what's the timeline for that contact with her? It was after he had departed base and after his vehicle was seen departing the restaurant. Thank you. I have no further questions. That day, I was given a letter by the Air Force which laid out the next steps in the process for the convening authority to review the findings and sentence and determine whether he wants to grant Kevin any relief by reducing the findings or sentence. I was given an opportunity to submit written matters that reasonably tend to inform the convening authority's decision on whether to reduce the findings or sentence in this case. For example, the letter advised that I could describe the impact Kevin Larson's crimes had on my life. This was a temptation for me because all I wanted was for this to go away. However, I learned that I must embody neutrality. I realized that whenever I got myself involved in trying to do something for Kevin's best interest, all I did was making things worse for him. I trusted in Kevin and his ability to hold strong so that his miracles would unfold according to his own faith. So I denied the opportunity to write a memorandum. The session was called to order at 09:58, 18 January 2020. Military judge. Please be seated. The court is called to order. The parties, with the exception of the accused, are present. The members are absent. Trial counsel is prepared to proceed to sentencing. The accused is not present. The military judge continued with the findings of Kevin's voluntary absence. The evidence supports accused had a plan prior to announcement of findings, pre-positioning the Jeep. The accused was aware of when the recess ended, and he has not been gone for more than 19 hours after he was scheduled to return. The accused communicated after the findings such that it supported that the accused's decision to absent himself was voluntary. The accused phone location is consistent with voluntary departing to Mexico or toward Mexico and is consistent with one of his purported plans, and there is no evidence that the accused's actions were compelled by any other person or that the accused is being held against his will, such as a kidnapping, smuggling, or otherwise. Consequently, the court finds the accused's presence was voluntary and sentencing may proceed in this case. Trial and defense counsel, do you have any additional motions or matters? Both trial and defense counsel took turns sharing their thoughts. The circuit trial counsel requested to withdraw the letters of character from the exhibits. Military judge. So just to make sure we're talking about the same thing, do you know how many character letters we're talking about plus the index? Do you know? Circuit trial. I believe it's 33 letters plus the index. All right, so your intention would not be to remove any decorations or any photos, those types of things? That's correct, Your Honor. So to the extent that I'm either off by 1 or 2 character letters, that is what the balance would be. The awards and decorations, the pictures, things of that nature. 10:38, 18 January 2020, the court-martial was called to order. Military judge. The court is called to order. The parties, with the exception of the accused, are present. The members are present. Members, as an initial matter, you may not draw any adverse inference from the accused absence at this point in the court-martial. The letters were removed from the members by the bailiff. U.S. Air Force was called as a witness for the prosecution being duly sworn, testified as follows by Circuit Trial Counsel. Can you please introduce yourself to the members, by which I mean your rank and your full name? I'm Captain Stephen Matthews. What is your duty position or your duty title with your squadron? Flight Commander Instructor Pilot. Do you know a Captain Kevin Larson? I do. Do you know a Captain Kevin Larson who was on trial this week? I do. How often would you say you have an opportunity to interact with Captain Larson? Daily. All right. And can you describe in a very general manner what those interactions are? Are they social interactions, professional interactions, interactions by the water cooler, at your desk? What is the general nature of those interactions? We have a daily roll call at 0800 every morning where he's normally present. If he's on duty that day, I speak to him briefly, see what his intentions are for the day, if he has any appointments that he needs to go to, what his general plan for the day is, and then usually see him at dismissal around 1500 or so. I would also sometimes ride in a van pool with him. So can you talk about what your duties are with respect to him, if any? Just managing his schedule, making sure he's present when on duty, making sure that he fulfills any mandatory appointments that he's supposed to go to, coordinating anything that comes up if he needs to take leave for any reason. If he has an appointment, I'd say Nellis. We're assigned to Creech, so if he needs to be here for the duty day rather than be up at Creech, general managerial things. Now, I want to ask you, do you have any information or knowledge about the accused, Captain Kevin Larson's character? I do. Do you have any information or knowledge about his performance of his duties? Yes. Do you have any information or knowledge about his moral fiber? Could you go into more detail about that? Do you have the gauge as to Captain Kevin Larson's morality? Would you feel that you have knowledge of or information about his moral fiber? To an extent, yes. All right. Do you have information or knowledge about Captain Larson's determination in this case to be rehabilitated in society? Yes. Do you have information or knowledge about the nature and the severity of the offense for which he was guilty? I do. Now, based on all of that information and all of that knowledge, have you formed an opinion as to whether Captain Kevin Larson has rehabilitative potential? Yes. Do you believe that Captain Kevin Larson has high rehabilitative potential? No. Do you believe that Captain Kevin Larson has low or no rehabilitative potential? Yes. That's all the questions I have, sir. Cross-examination by Circuit Defense Counsel. Good morning, Captain. Good morning. Rehabilitative potential, the ability to be a protective member of society. You understand that's what we're talking about, correct? Yes. That it's not unique to the military? Sure. That we're talking about Captain Larson's ability to simply be a productive member in society at large. You understand that? Yes. And it's your opinion that Captain Larson has low to no ability to be a productive member of society? My intention on the statement would be rehabilitative status to remain in the military. Okay, so let's talk about as a member of society, because that's not what we're talking about. Okay. I want to know your position on Captain Larson's rehabilitative potential as a member of society, as a fry cook at McDonald's, as a guy who works at Foot Locker, as somebody who can contribute to our society at large. Do you have an opinion on his rehabilitative potential? Yes. What would you say that is? I would say that outside of the military, for whatever function that he decides he wants to serve in time, having fulfilled commitments for whatever he's found guilty of, he can, yes, serve a function in society. And prior to, well, let me ask you this. When were you asked to testify in this court-martial? Less than 15 hours ago. Circuit Trial Counsel, Your Honor, may we have an Article 39A before this question is asked? In light of the court's previous ruling, we would object to this question. The court took recess.